Good evening, ladies and gentlemen. How do you celebrate your Freedom Day? What is that you regard as your freedom? What have you attained? Okay? From which bondage you are free? It has been a hectic week in the sense of Maiwa murder trial. For example, we are not sure if the accused in this trial, they've been enjoying their Freedom Day, looking at how the state is conducting the case. Ladies and gentlemen, the state keeps on bringing new exhibits, new evidence, new witnesses, including new issues like the bank statements, right in the middle of the trial. It means that the state, whilst the trial is on, they are still investigating. The state is trying to close all the gaps in their case. If the defense counteract the state allegations, then the state will try to come up with something to support their allegations. So it means that the state is unsettled. And by so doing, the state is violating the rights of the accused, which they must enjoy in this constitutional democracy of ours, which were founded and which are inside this constitution. Ladies and gentlemen, the right to a fair trial. In terms of section 35 sub 3 of the constitution, not forgetting sections 155, 156, 157, and 186 of the Criminal Procedure Act as amended. In this sections I mentioned in this Criminal Procedure Act 51 of 1977 as amended, it explains the procedure that must be followed in a trial, in a criminal matter. That's why it is Criminal Procedure Act. Hence, we also have civil procedure. Ladies and gentlemen, it means it is the procedure that must be followed when a criminal matter is dealt with. Section 155, 156, and 157, including 186 of the Criminal Procedure Act. And those sections, they must not be inconsistent with the Constitution. Section 35 sub 3, notwithstanding the limitation clause, which is section 36 of the Constitution. So, the state is the terminatis litis. It is the state case. The state is the initiator of the process. Yes, BK. Hi, P and J. The state, if it wants to proceed on a matter and it keeps on bringing new exhibits, new evidence, new witnesses, strip by strip, it derails the progress of the matter. Remember, ladies and gentlemen, all those sections I mentioned in both in the Constitution and the Criminal Procedure Act are very clear when it comes to a criminal case. All the blame if not 99%, must go to the state with regard to, sorry, ladies and gentlemen, the delay and the derailing of the process of this matter. In practice, before a matter can be set down for trial, as per State versus Chabalala, the defense will be vanished with the copies of the docket. After the defense are vanished with the copies of the docket, the legal representatives, they must go and prepare for trial and take proper instructions from the client. Sometimes when you go through the copies of the docket and you take instructions, after you've analyzed everything, you come to a suggestion to the client that maybe we must make representations, or maybe we must request for further particulars from the state. Kofi under chain, Osia, and all other information is the main reason for this book and Arike. So you see, the Criminal Procedure Act, all of it cannot be unconstitutional. Hi, baby boy. Certain sections in the criminal procedure, they can be inconsistent with the Constitution. However, there are those sections in the criminal procedure which are consistent with the Constitution. There are those case laws that came before the Constitution. Those were heard before the Constitution. When you refer to them, you can see this case law is consistent with the Constitution. And there's those other cases, when you look at them, you can see, no, this ruling of this case is inconsistent with the Constitution. Pamela Hashe, hi. How are you? So I hope you understand me, ladies and gentlemen. I'm talking about freedom, Pamela Hashe. What is that you have unchained yourself from? The bondage. When you look at whatever is happening around you, you are free from what? Because today is the Freedom Day. I'm referring to the Criminal Procedure Act, and also I'm referring to the Constitution of the Republic of South Africa as well, which was founded in 1996. That's why it says 25 years of celebrating the Constitution and 30 years of celebrating the first right of the majority of the people in the country to vote. And this act, the Criminal Procedure Act, must at all times be consistent with the Constitution. So, I was saying, I don't think the accused in the sense of Miwa murder trial, they enjoy their rights invested to them in the Constitution and provided to them by the Constitution. I'm fine, Pamela. Johanna Maseko, hi, how are you? So, looking in the manner in which the state is presenting its case, ladies and gentlemen, the state is conducting trial by ambush, which is inconsistent with the Criminal Procedure Act and the Constitution. Before I can go through those sections I mentioned, ladies and gentlemen, I just want to deal with the issue of communication between legal representatives and the presiding officers. Okay? Sibanda Sikatele, thank you very much. We must appreciate. In practice, legal practitioners who appear before a particular presiding officer, they're not supposed to directly communicate with that presiding officer because of ethics and protocol. The legal practitioners, if they have anything they want to address out of the courtroom posture, they need to write an email to the secretary of the judge or phone the secretary of the judge. Hence, all the judges, when they appear in court, they have secretaries. They have a clerk in front of them, ladies and gentlemen. And all arrangements, they go through the secretary of the judge. However, it is very important that because the prosecution are the initiators of the proceedings, they are dominantis litis. Sometimes, if defense teams cannot get hold of the clerk of the judge, they'll communicate to the prosecutor. Because the prosecutions are the ones who have access to the judges, because they are the initiators of the process. They are dominantis litis. We will accept that whatever they are communicating with the honorable judges, it will be within the framework of ethics and nothing else, ladies and gentlemen. And it is unfortunate that some of the presiding officers would like us to not abide by the rules of the profession and ethics, codes of conduct of different bars and the LPC. For example, I had an issue with a particular presiding officer when I was supposed to be in court, and I had a breakdown. Okay, I could not make it to court, and the presiding officer managed to get the message from my clients that I cannot make it to court. For in case I don't have contact details of the prosecutor, I can communicate the message through my clients. Because, ladies and gentlemen, in certain courts here in South Africa, we are not allowed to have direct contact or contact details of the prosecutors. They can only give us landline. However, if there's an emergency, then the landline won't work. Hence, we give the client message, especially if the client is on bail. But now, when my clients communicated that to the presiding officer, the presiding officer had an issue with the fact that why same was not communicated, why I didn't contact the prosecutor. I could not contact the prosecutor because I didn't have the contact details of the prosecutor. So on the next appearance, the coming Friday, I'll have to address the Honorable Court, inform the Honorable Court that I don't have the contact details of the prosecutor, direct contact details. Looking at the history that some courts in a particular court room or court building, in some court buildings, the management there doesn't allow public prosecutors to exchange numbers with private attorneys, which I found it very shocking, ladies and gentlemen. And once the state, I'm going back to this issue of presenting evidence piece by piece, new evidence piece by piece. Once the state presents a new piece of evidence, whether it's an exhibit, affidavit, or statement, even witnesses, the defense must go back to their clients and take instructions, ladies and gentlemen. And by so doing, the state is derailing the progress. And it might happen that if the state provided the defense with everything from the beginning, maybe instructions could have been different, or the defense team's legal representative, they were going to advise their client differently. I'm looking at this issue of bank statements, ladies and gentlemen. Okay? If these bank statements were presented long time ago, before even the trial began, to the teams, the defense teams, they should have taken instructions long time ago from the clients and maybe advised their clients accordingly and took instructions differently. So the state, by so doing, is creating an impression to the Honorable Court that they are unsettled and they don't know what they're doing. On the other hand, they create a bad reputation on the defense team before the court, because the Honorable Court will say, but earlier your defense was this and this, earlier your submission was this and this, but now you're changing, your submission is this and this. You're changing because you've been given other documents by the state. So the state must be blamed for any delay in the sense of your murder trial. So, ladies and gentlemen, do not forget to give thumbs up, subscribe, follow, comment, like the channel, and send us super thanks to promote the algorithm of the platform. Because I've noticed these days that the algorithm is getting affected, ladies and gentlemen, if we don't live stream and we do not participate. This channel, we are here to teach each other, ask questions and clarify to each other. No one is above another. This channel belongs to all of us. We are not taking sides. We are looking at the facts as they are already. Ladies and gentlemen, I apologize. The network is again. I was just saying, in this platform, we are helping each other. This platform belongs to all of us. And if there's something you don't understand, I have the right to ask, as long as we respect each other and we keep the community guidelines. We don't play the player, but we play the ball. I was trying to say to you, ladies and gentlemen, as I said before, I want us to go to Criminal Procedure Act 51 of 1977 as amended, which is being amended now and then. Hence the word as amended. And we also now have Criminal Procedure Amendment of 2002. I'm looking at section 155. Okay. Persons implicated in the same offense may be tried to Section 155 sub 1. Any number of participants in the same offense may be tried together, and any number of the accessory after the effect may be tried together, or any number of the participants in the same offense and any number of the accessory after the effect may be tried together. And Each such participant and each such accessory may be charged at such trial with the relevant substantive offense alleged against him or her. Subsection 155 sub 2. A receiver of property obtained by means of an offense shall be, for purposes of this section, be deemed to be a participant in an offense in question. So this section means, ladies and gentlemen, that let's say in the sense of murder trial, those people who were alleged to be were in the house and they're alleging that the people who are appearing before the court now, they allege that they are the perpetrators. It is the right of the state. It is upon the state to decide whether they want to include some of those people in the house, if not all of them, in the charge of docket 636, together with these alleged people they say that the ones who committed the offense. Alternatively, those people in the house can be charged separately. They can be arranged to appear in court and tried separately on the same docket 636 or docket 375. And another option is to separate them. Those in the house who are alleged to were in the house and they're alleging that they are the victims, they can also be tried separately, even though they're the accessories of the effect. And even the accused who are now appearing in 636, they can be charged separately. The decision is upon the state, especially when you look at Section 105, capital letter A, and Section 204 of the Criminal Procedure Act. One of the accused might say, no, I want to enter into a plea agreement with the state. Then they will be charged separately. The other one says, no, I want to be a 204 witness, Section 204. Then once that it becomes the witness and the court is finding that this person was not credible, then the state will charge that person separately. Same applies with those people in the house. With regard to the issue of receiving a property in the matter of Lear, the case defender, may his soul rest in peace, if he realized that they've charged 6 or more people there, some of them can be charged with the offense of receiving suspected stolen good, receiving stolen property, or possession of stolen property. Some may also be charged with accessory after the effect or murder. Others can also be charged with robbery with aggravating circumstances or robbery. Or all of them can be charged with a particular offense, and the state can raise the principle of common purpose. Just like in the matter of Tips and Aka, aka the state needs to join those people who are in Swaziland, those two brothers, or else they can charge them separately. The quote of the day, is about freedom. The freedom in our country. What is that you consider you gain bondage you had before and now you have attained freedom? In this instance, I don't think the people who are in the matter of murder trial as alleged, they are enjoying any of the fruits of freedom when looking at how the state is conducting its case. And I apologize again, ladies and gentlemen, the network is not friendly at all. Sikha Mukota, greetings. Thank you very much, but I'm an attorney. Okay, thank you. I have relatives there in Sweden as well. So you're also my relative. I'm also Tswana. I have Matekes there in Sweden. So the issue here, I was discussing about the rights, okay, what you enjoy in this day of our Freedom Day. What have you unchained yourself from as a bondage? Now, I'm saying the accused persons in the sense of Mayweather trial, they don't enjoy their rights which are in the Constitution, looking at how the state is conducting its case by bringing evidence trip by trip. The state conducting investigations whilst the matter is on trial, and it is the state that is delaying the matter. Section 156. Persons committing separate offenses at the same time and place may be tried together. I was also looking at I was also looking at section 155 and 156 of the Criminal Procedure Act, whereby an accessory of the same fact may be charged with the principal alleged perpetrator of an offense. Okay? Buddha, hi, how are you? PJ, how are you? Ke a bona wena morolong setati o delete o start wa go kae? O start wa go di 16. Ke a bona o delete. So, ladies and gentlemen, you must also guard against community guidelines. Let's adhere to them and protect our privacy. And also, let's look at section 157, joinder of accused and separation of trials. That's why I did say, Mokota, that in that matter of the murder of Tips and AKA, okay, those gentlemen who are now in Swaziland, they can be brought and joined on this matter, which is in South Africa, or the trials can continue separately, okay? So, even in this matter of sense of Mayor murder trial, the people who are in the house, who are alleged to were in the house, and these ones who are already appearing, they can be together, yeah. They can be charged together, okay? Or they can be charged separately. Before we wrap up, ladies and gentlemen, together, yeah. Before we wrap up, I've never seen super thanks. Please send super thanks. And if there's any comment or question I didn't answer, once this live stream has been uploaded on the platform, I'll be able to reply or answer and help each other. I want us to go to section 35 sub 3 of the Constitution. Section 35 sub 3 of the Constitution deals with every accused person has a right to a fair trial, which include the right, A, to be informed of the charge with sufficient detail to answer it, B, to have adequate time and facilities to prepare for a defense, C, to a public trial, D, to have their trial begin and conclude without unreasonable delay, E, to be present during the trial, F, to choose a legal representative, G, to have a legal representative assigned to them if they are unable to afford one, H, to be presumed innocent and to remain silent and not to testify during the proceedings, I, to adduce and challenge evidence, J, not to be compelled to give self-incriminating evidence. So basically, the state is the one that is violating the rights of the accused. Okay? And let's not blame the Honorable Court, ladies and gentlemen, please. The Honorable Court doesn't know what the state will present before it until such evidence is before the court. And the Honorable and if the state keeps on giving the defense new exhibit, new evidence, and new witnesses coming in, it's the duty of the defense to object such action. Together, yeah. I apologize for that, ladies and gentlemen. I apologize. I really apologize. It is the duty of the defense to object tactics from the state side, because the state is conducting trial by ambush, and they don't give the defense sufficient time to formulate a defense by presenting evidence in court, new evidence in court, and want the defense to deal with it. The defense has the right to consult with their clients and take instructions, in the proper instructions, not in a hush or in a rush manner, rushing to present the issue before the court or to answer to the state allegations. And if the state keep on conducting their trial in that particular manner, the defense has the right to object. I don't know why the defense is not objecting. You cannot just accept each and everything on face value as the defense team. You must look at it. And even the court, at certain times, the Honorable Court needs to intervene and call the state to order, ladies and gentlemen. Let's say, for a typical example, if the state managed to give the defense all these things they're doing now before the trial began, the defense maybe should have formulated a defense in a different way and took instructions from the client in a different way or advised the client differently. So all the blame must squarely go to the state, not the defense and not the Honorable Court. But the defense must also start to act and stop being very lenient to the state. It's the duty of the defense lawyers to protect the rights of their clients. Ladies and gentlemen, question is, why are there anyone in South Africa's judicial level not reacting to what's happening in that court proceedings? The whole world is watching what's happening in that court. That's a good question. And it put us on a map, world map, in a certain way. However, as I said, we cannot blame the Honorable Court in most of the instances when this matter is being delayed. We must blame the state with the manner in which they are conducting their case. And it is up to the officials who oversee the proceedings. It is up to the officials who oversee the prosecution. It is up to the officials who oversee the Honorable Court. It is over the officials who oversee the Honorable defense teams on what to do about it, and to check whether they put us on the world map in a good way or a bad way. And it's very important that we must be able to see actually where does the big problem originates from, where all these things start. Okay, ladies and gentlemen. And with regard to the matter of R versus Hepworth, it entitles the court to where it's necessary and important in the interest of justice to intervene, even though the defense is quiet. The state of the matter of R versus Hepworth 1928 empowers the court to call the state into order, because whatever agreement is reached between the state and the defense with the exclusion of the court, it's got nothing to do with the court. It's got nothing to do with the Honorable Court in the manner in which the Honorable Court would like to see the matter taken forward. So I just hope that the defense, whenever the state comes up with something new, it doesn't just take it on face value. They must look at the results of such decision they make, because it might affect the whole trial. For instance, the Honorable Court might say to the defense, but earlier you submitted your defense as this one, but now you're changing. Of course, the defense might change their submissions, because is this the state that comes up with new evidence, exhibits, or witnesses now and then, drip by drip. And on the issue of the bank statements, ladies and gentlemen, for example, I can have a bank account and give my child the card, and my child is in another location and I'm staying in another location. Or I can give it to my mother or my grandmother, and they are in different locations from me. They will be able to use those cards without my presence. And when the state presents a picture, as it did, the defense will have to scrutinize that picture. The defense cannot take anything presented by the state on face value, especially in this sense of murder trial, because the prosecution is famous of conducting trial by ambush. The defense need to analyze that picture, okay? And it is very important that Honorable Advocate Mushololo did say the employees of the bank must come, and also the source of where that picture originates from need to be scrutinized, ladies and gentlemen. It's just like when you receive copies of the docket, when you look at the affidavit, you have to look at the date when that affidavit was commissioned, and the date it was signed, and where it was commissioned or where it was signed, and who commissioned it and who signed it. You look at all those things, ladies and gentlemen. Okay? I just hope that the defense will stop being too soft to the state, and the state must play according to the rules of the game and conduct the trial in a fair manner. If you can recall, when I was still appearing on the matter with Advocate Tefo, and thereafter I took over from Tefo, we were concerned in the manner in which the state is conducting themselves. And the matter started de novo. And I think, in inverted commas, it might have allegedly been started de novo deliberately in order to allow the state to fix their mistakes. Because if you have seen that certain witnesses who testified in a particular manner, hi, Alexander Boda, the witnesses who testified in a particular manner before Honorable Judge Maumela. In this matter now, before Honorable Judge Mkwashing, they have changed their evidence. They tailored the evidence in order to suit the state case. So, I humbly submit that whatever is happening, all these shenanigans, we must put the blame on the state, because the state is Dominitis litis. I thank you so much, ladies and gentlemen, for joining us at this short notice. Thank you for joining at this short notice on this Freedom Day. I want us to go and enjoy the Freedom Day before it's too late. I also must go and enjoy the Freedom Day before it's too late. And you are welcome to post questions on the platform. And once this live stream has been uploaded, I'll be able to reply and answer your questions. Most importantly, do not forget to send super thanks. Please, ladies and gentlemen, let's grow this channel. It's not one person's channel. The channel belongs to all of us. And the other issue I just want to address is the issue of petition. I heard people talking about it. A petition to say a presiding officer must be removed from a meeting. And on this same platform, I saw people raising the issue of a petition. Okay, thank you very much, Mukota. Well, I'm not sure it's me or isn't that, but I'm just saying thank you, Mukota. When a legal representative appear before a court, the legal representative get instructions from the client and carry over the mandate to the Honorable Court. It is the Honorable Court that makes a ruling. If you make an application before a Honorable Court, you're not the one who's going to make a judgment. It's the Honorable Court. So the public must note that when a legal representative is being paid financial instructions to go to court to ask a ruling on a particular issue, it doesn't mean that that issue will automatically be in your favor because you paid the legal representative. No. The Honorable Court will scrutinize all facts before it and comes to a ruling. If you're not happy with the ruling, you can review it or appeal it. In some instances, you can resign or vary. So whatever petition they're talking about, it cannot be. No, that's not how things work in a constitutional democracy in South Africa, because in terms of the constitution, each and every person has the right to have access to courts, have the right to have their matters heard and adjudicated fairly by the honorable courts, ladies and gentlemen. So when they say there's a petition, they must sign that petition, okay? And they agree on that point. After they agreeing on that point, they appoint a legal representative, and a legal representative will make an application on their behalf. Okay, ladies and gentlemen. And those people who sign that petition, they must show local standing. They must show standing in the court. Why they are bringing that application? What is their interest? Okay? And they must show that they have interest because this matter is of a public interest. So the public want to see justice unfolding according to their thinking. And then when they want to see justice unfolding according to their thinking, then they must go before the Honorable Court and make submissions. That is when a Honorable Court will make a ruling. The mere fact that you paid an attorney to represent you, even if in any ordinary matter, ladies and gentlemen, the mere fact that you paid a legal representative to represent you, whether it's a criminal matter or a civil matter, that must be separated from the submissions that will be made in court and the order that will be handed out. You pay a legal representative to make certain submissions before the Honorable Court to protect your rights and make an application for a particular order you require. You pay for that order. But the court cannot just give you that order. The court will look at all the facts before it comes to a ruling, which is supposed to be fair and just. And if you are not happy, you must follow the next step. You must come before the same Honorable Court and make an application for leave to appeal. And if you are not successful with the leave of the appeal before the same court, then you petition the same court to a higher court, Supreme Court of Appeal. If you're not happy with the ruling of the Supreme Court of Appeal, then you petition the president of that Supreme Court of Appeal. And if you are not happy with the ruling, then you go to the Constitutional Court. And if you are not happy with the ruling of the Constitutional Court, then you can either resign, vary, or review the Constitutional Court ruling, because you cannot appeal the Constitutional Court ruling because it's at the climax, is the last court. And those people who have access, direct access to the Constitutional Court from a higher court, they only do that if the matter deals with the Constitution concerning the administration, like the Parliament, and also cabinet and issues concerning the presidency. I hope you understand me, ladies and gentlemen. So no one can deny them to do whatever they want to do. They can do a petition, but doesn't mean that petition will be automatically granted. It doesn't go to the Honorable Court, that petition. It goes to the legal representative who must present it before the Honorable Court based on the instructions from those people who signed it as a group. I thank you. Thank you very much, ladies and gentlemen. Let me check Alexander Buta, what's up? Alexander Buta, are you? And I just want to finalize, ladies and gentlemen, if there's no any other clarity-seeking statements or questions after this live stream has been uploaded, you're still at liberty to pose questions or send clarity-seeking statements or sentences, then I'll revert to you. And you must remember, this platform is not one person's platform. It belongs to those who participate in it, ladies and gentlemen. And I'm happy we must always keep in mind the community guidelines, respect each other, and don't play the players, play the ball. We are not here to take sides in this platform. We are here to look the facts as they are and to find proper ways to deal with the issues. If a reasonable person and on the face of everything, we see things that they're supposed to be in this way, they are supposed to be addressed. You are not dealing with the matters that are yet to be before the Honorable Court. And we are dealing with the matters that are already dealt with the court and are in the public eye. Lastly, for a typical example, in practice, private legal practitioners are not supposed to directly communicate with presiding officers, but they do so via the secretaries or the clerks of the court or the secretary of a particular honorable judge because of ethics and code of conduct. However, in a criminal matter whereby the state is the dominus litis, is the initiator, the state can have direct access with the Honorable Court as long as ethics are maintained. For example, if the defense are unable to get hold of the secretary, either by telephone call or by email, and there's no response from the secretary when you send email, or in the event that is very urgent, you want to contact the secretary, you want to contact the secretary through a telephone call, you are unable to reach the secretary, you can contact the prosecutor, who in turn will contact the secretary. If he's unable to get hold of the secretary, then the prosecutor will contact the judge, inform the judge. I hope it's clear, ladies and gentlemen, and I'm looking forward to the future interactions with everyone. And I would like to say, have a nice one. And here in South Africa, it's at night. Good evening, ladies and gentlemen. I thank you.